Good morning. Welcome to our Law Enforcement Data webinar with the Data Practices Office. Thanks for joining us. Our office is a resource on all things data practices and the open meeting law. Most of what we do is answer questions about both of these laws. We also provide training on different data practices and open meeting law topics, and now we're offering these short webinars. Today's webinar is the second part in our 5-part series on law enforcement data. The first webinar is already on our YouTube page if you missed it. We covered an introduction to law enforcement data, including active versus inactive investigations, as well as protected identities. I'm going to go ahead and share my screen with you to walk through how to access our previous webinar content. The link that I will use to access our website is listed on this slide for you. Okay, so this is our website. When you go to our website, you can click on News and Events, and then Webinars to bring you to our webinar page. When you're on our webinar page, if you're experiencing any audio issues during our event, you can click on this audio FAQs link, and it'll bring you to some frequently asked questions to try and troubleshoot some of your audio issues. You can also access our previous webinar content by either clicking the YouTube channel link here or going to the bottom of our page and clicking the YouTube icon there. We also have, under our Resources tab, training materials and videos, links to individual videos, as well as a link to our Data Practices YouTube channel as well. So once you're on our YouTube page, you can either view all of our videos on the Videos tab, or you can click on Playlists, and we have our various webinar series listed in playlists here for you. Our Law Enforcement Data webinar series is here, and you can see that the first webinar in the series is already posted. After this webinar, we're recording it. We'll probably have it posted within the next couple of days for you to view. If you'd like to download a copy of today's PowerPoint, I'm going to share the file with you. You can download and save it to your computer now. Okay, so you should have a pop-up box on your screen right now that you can save the PowerPoint. I'll give you a few minutes to do that. Okay, for those of you who didn't get a chance to download or save the PowerPoint now, I'm going to also share it again at the end of the webinar. So today's webinar will cover the classification of law enforcement videos, including body camera data and dash cam video. We will leave some time for a Q&A session at the end of the webinar, so feel free to send in your questions as you think of them using the Q&A panel on your screen. When sending in the questions, please send them to all panelists so we can make sure we see them. All right. The classification of law enforcement video depends on what type of video is at issue. Generally, government data are classified by the content of the data rather than the type of media used to collect or maintain the data. However, there are a few exceptions to this rule. Body camera videos are one of these exceptions and have their own classification in 13.825. Other law enforcement videos that are not collected through a body camera, such as dash cam video or cell phone videos, are governed by 1382, or they're presumptively public. This legislative session, the legislature also discussed drone videos, which will have its own statutory section that becomes effective August 1st, 2020. We are not going to cover drone data in this webinar, but we'll likely do a legislative update in a couple months to discuss all new data practices and open meeting law legislation, so keep an eye out for that. Let's get into the classification of body camera videos. If body camera data are at issue, the classification of the body camera data will depend on whether the investigation is active or inactive. If the investigation is active, 13.825 subdivision 2A3 indicates that the body camera data are governed by 1382 subdivision 7 while the investigation is active. This means that when there's an active investigation, the body camera data become confidential, active investigative data. But then once the investigation becomes inactive, the body camera data revert to 13.825, which generally classifies body camera data as private or non-public, which I'll talk about in greater detail in the next slide. However, in certain situations, inactive body camera data become public. If they document an incident where an officer discharges a weapon in the course of duty, not including training or killing an animal, or the data documents the use of force of a peace officer that results in substantial bodily harm, or a data subject of body camera video may make the video public. However, if the body camera footage documents other data subjects who do not consent to the release and they're not peace officers, those individuals must be redacted from the video. And the final exception that would make the body camera data public are if they're public personnel data under 1343 subdivision 2. Those remain public, like public employee disciplinary data. Subdivision 2 of 13.825 also mentions that body camera data may be redacted if it's clearly offensive to common sense abilities. Law enforcement agencies may also release any not public body camera data to the public to aid law enforcement, promote public safety, or dispel rumor or unrest under the public benefit data section in 1382 subdivision 15. Whether law enforcement uses body cameras or any portable recording system is also public in the context of arrest data and response or incident data. Body camera data that are inactive investigative data and do not fall within one of the 4 public exceptions in subdivision 2 are generally classified as private or non-public. 13.825 subdivision 4 discusses access to body camera footage by data subjects. This subdivision indicates that data subjects have access to private or non-public video. So an individual whose image or voice appears in a body camera video can view the unredacted video, including viewing other individuals and peace officers who appear in the video, except for undercover peace officers. Note that this access or right to view the data under the subdivision is different than the data subject's right to obtain copies of the data. The data subject may only view the unredacted footage, but if they want copies of body camera videos in which they appear, the identities of other data subjects must be redacted if those data subjects haven't consented to the release. Again, if a data subject requests that body camera video be made accessible to the public, the other data subjects, not including on-duty peace officers engaged in an investigation or response, must either give their consent or they must be redacted from the video when it's made public. Law enforcement agencies must always redact undercover officers from body camera videos as well. As for retention, generally entities rely on their retention schedules to determine how long they must keep official records. However, 13.825 imposes minimum retention requirements for body camera videos. All body camera videos must be retained for at least 90 days. If body camera video documents use of force, discharge of a weapon in the course of duty, or there was a formal complaint against an officer, the videos must be retained for a minimum of 1 year. Once these 90-day and 1-year thresholds are met, the law enforcement agencies must follow their retention schedules, which may require longer retention of the videos. 13.825 also indicates that entities must allow requests for longer retention periods of body camera videos as well. There are quite a few additional requirements outlined in 13.825 that law enforcement agencies must follow if they use body cameras. Law enforcement must maintain an inventory, which contains public data about the number of body cameras the agency owns, daily records of the cameras used and the precincts in which they were used, policies and procedures for use, the total amount of video data collected, the agency's retention schedule for body camera data, and the agency's destruction procedures. For subdivision 7 of 13.825, the responsible authority for law enforcement agencies must have written procedures that specifically outline access to body camera data. These procedures must ensure that law enforcement personnel only have access to not public body camera footage if authorized in writing by the head of the law enforcement agency or their designee for a legitimate specified law enforcement purpose. Body camera data may only be shared with or disseminated to another law enforcement agency, a government entity, or a federal agency upon meeting the standards for requesting access to data as provided in subdivision 7 as well. Law enforcement agencies must also arrange independent biennial audits for their body camera data and whether they are appropriately classified, how the data are used, whether the data are properly destroyed, and verify compliance with subdivision 7 and 8, which are the authorized access and data sharing sections. If law enforcement obtains new surveillance technology that expands the scope of surveillance capabilities with a body camera beyond video or audio recording, the agency must also notify the BCA within 10 days. There are also certain vendor requirements outlined in subdivision 11 and increased penalties for willful violations in subdivision 12. The last thing to note here is that 626.8473, which is on the slide there, requires law enforcement agencies to allow for public comment and create written policies and procedures before it purchases body cameras or implements a body camera program. The Commissioner of Administration recently issued Advisory Opinion 20-004, which discusses the classification of body camera video during an active investigation. In this opinion, the Commissioner states that active criminal investigative data are not classified by Section 13.825. Instead, active investigative body camera data are classified by Section 13.82, Subdivision 7. Once the investigation becomes inactive body camera data are classified as provided in Section 13.825. In this situation, in this advisory opinion, the body camera data were part of an active investigation into the actions of the officers responding to a call for assistance. Therefore, the body camera data and the other law enforcement active investigative data are classified as confidential or protected non-public until the investigation is inactive, when the body camera data will revert to 13.825. With law enforcement videos other than body camera data and eventually drone data, these data are treated as regular law enforcement data. So how these data are classified depends on whether there's an active investigation. These videos are confidential or protected non-public when there's an active criminal investigation and public when inactive, subject to protected identities or unless clearly offensive to common facilities, or they're presumptively public. However, during an active investigation, confidential, protected, non-public law enforcement data may still be released pursuant to 13.82 Subdivision 15 as public benefit data in order to promote public safety, aid in the law enforcement process, or dispel widespread rumor or unrest. We're going to walk through a couple scenarios to apply some of these law enforcement video classifications. Scenario 1, a member of the public makes a data request to the local police department for dash cam footage that depicts an officer responding to an adult medical emergency. There was no criminal investigation. What is the classification of this video? The first step is to determine what type of video is at issue. Here we're dealing with dash cam video. So we aren't in 13.825. So we know that the data are either 13.82 data or they're presumptively public. The next step is to determine whether there is an active criminal investigation. The response in this scenario solely relates to medical assistance. So there's no crime being investigated or an investigation that would bring this video into 1382 as active or an inactive investigative data. It's also important to note here that there is not a general classification for responses to medical calls that would protect an individual's identity. As a result, this video would be presumptively public, meaning that anyone could obtain access to this video for any reason. Okay, now let's imagine the same scenario, but instead of dash cam video, we only have body camera footage. So only the medium for collecting the videos changed. Now we know to start with 13.825 in our analysis, which governs body camera data. Then we need to determine whether this is active investigative data that will be brought into 13.82 subsection 7. Again, this response solely relates to medical assistance. So there's no crime being investigated or an investigation that would bring this video into 13.82 as active investigative data. So we stick with 13.825 as the governing statute. 13.825 says that all body camera video data are private or non-public unless one of the exceptions listed in subdivision 2 applies. The subdivision 2 exceptions require that the video document either the discharge of a firearm in the course of duty, an incident resulting in substantial bodily harm, public employee disciplinary data, or that the data subject requested that the data be made public. In this scenario, none of these exceptions apply. As a result, the video is simply private or non-public 13.825 data. So although the incident in each of these scenarios is the same, the classification of the video changed based on the medium used to collect the video. All right, here's a new scenario. Here, law enforcement are responding to a domestic disturbance, and officers are wearing body cameras. The officers enter a home and observe a man hitting a woman. There is a child and another adult woman in the same room. The officers arrest the man for assault and interview each of the adults. The investigation is currently active. The next day, a neighbor requests a copy of the body camera videos documenting the response. What should law enforcement release to the neighbor while the investigation is active? Okay, so again, we know to start with 13.825 in our body camera data analysis because the type of video here is body camera data. Then we need to determine whether there is an active investigation that will bring the data into 1382 subdivision 7. Here, there is an active investigation, so the body camera data are brought into 1382 subdivision 7 as confidential active investigative data while the investigation is active. So because the body camera data are brought into 1382 during the active investigation, the neighbor has no access to the body camera video because it's classified as confidential. However, the neighbor does still have access to public data in the incident report, which would be the data that are covered under 1382 subdivisions 2, 3, and 6, which we like to refer to as the super public data. And she has access to that super public data, whether the investigation is active or inactive, subject to any identities. All right, so we have time for questions. Please send them to all panelists in the Q&A panel. While you're thinking about your questions, we just want to make another plug for another office at the Department of Administration, the State Demographic Center, which is leading the work on the 2020 census over the next year. We're highlighting this work because a good census is the foundation for a fair democracy, and we know that you all want to be counted, and the folks that you work with and serve want to be counted as well. You can learn more about the census at the website listed here. This is going to allow Minnesotans to keep our representation in Congress and get the funding for needed services. I'm also going to put PowerPoint up again for those of you who missed it the first time. while we're taking questions. One second here while I upload that again. Okay, so the file transfers up. You should be able to download and save a copy of the PowerPoint from today. All right, so we're going to start taking questions. If you hear a pause or some silence, don't worry, your audio is working. It's just because we're trying to read all the questions and make sure we get to them.
Okay, thanks for your questions. Keep sending them in. We have one question about how does body camera, squad camera, video, etc. interact with Minnesota Rules 1205.0500, which has the requirement to provide a notification that a minor individual has the right to request that parental access to private data be restricted. So Minnesota Rule 1205.0500 gives minors the right to ask that their data not be given to their parents, for instance. So I think the way that it interacts is that it requires that you have that a government entity has some notification. A lot of entities put that information in their access policies, the access policies that are required by 13.025. So it's really up to the entity how they provide that notice, whether there's an additional step that you want to take. Whenever you get a request for information that involves a minor, if you're a government entity, if you're a law enforcement agency, you certainly can, as a customer service, reach out to that minor and let them know that they have this right. You don't have to, but that's something that you could do. And then there are policies required, of course, for body-worn cameras and for that data. So you could also include that information in that policy as well. So certainly I've seen them in access policies, and so that's a way to address those rights. And we have a question about audio in body camera video, which is what about the redaction of audio from a subject that needs redacting from a body-worn camera video? Do you remove the audio completely or distort it? So the law obviously doesn't get into that detail, but basically you're just de-identifying that data. So to the extent that distorting works to do that, I think you could. Removing it completely obviously is another option. So I think either of those would work. The idea would be to de-identify that data so that people couldn't tell who's speaking there. When can the public access interviews with witnesses and suspects if they're recorded on a body camera video? So here's where section 13.825 controls, because during an active investigation where law enforcement might be interviewing people and collecting that information, those are confidential, protected, non-public, and then once that investigation is inactive, we go back to 13.825 where it says that those data are generally private. So the public is probably not going to get access to those videos except and unless there was some sort of court process where maybe it was entered into evidence, and as long as the judge hasn't put a court order around that video, then at that point for subdivision 1382 subdivision 7, the public may get access. That part is not clear about when it's interacting with the court process, but generally that is the difference between body camera video versus video that's being shot by a dash cam, which would become public once the investigation is active. Body camera data generally becomes private after an investigation becomes inactive. There's a question about, can you give an example of data subject makes data public with applicable redactions? What situation might this happen? So this is one of the exceptions to law enforcement, to body camera data is generally private. Under 13.825, subdivision 2A2, a subject of a body camera video that is private can request that it be made accessible to the public. What the provision says, and they acknowledge there, I think there's some drafting issues, it says, except that if practicable, data on a subject who is not a peace officer and who does not consent must be redacted. So that means if I'm in a video, I can say I would like it to be public, but if law enforcement does not have consent of the other people who are identified, they have to be redacted. So those would be the applicable redactions under 1382 subdivision 2A2.
We have another question. It asks, can the public ask for a transcript of the body camera video? So if the body camera video is classified as private or non-public, the data subjects in that video still are subject to that private or non-public classification, and the entity has no obligation to create a transcript of the video. That would be creating data in response to a data request rather than providing data that already exists. And then further, the transcript may contain private or non-public data that would identify those data subjects. So if an entity chose to create a transcript, they'd still have to redact any identifying information from it.
This question is asking about a situation where there are multiple officers on scene and not all officers capture a particular data subject who at some point requests a copy of the video. Does that data subject only get the video where they appear or all the videos related to that incident? They would only get the video where they appear or can be heard because it's related to both your image and your voice. So it's not related to the full incident that they may have seen or been a part of. It's just where they can be seen or heard. They would get access, meaning they could come in and take a look at it, and then they could get a copy if you were able to redact the other people from that video. So I want to give folks just a little more time. I don't see any other questions right now, so if you have some, feel free to send them in. Otherwise, we will wrap up. But like I said, I'll give you a couple more minutes to think about it if you want to ask your questions.
right, we're going to close for today. Please provide us with feedback on the survey that will pop up after you exit WebEx. Stay tuned for a delivery notice for part 3 of our law enforcement series. If you have any questions or you have any requests for certain data practices topics that you'd like us to cover, please feel free to let us know in the survey. Thanks.